The next matter is Firearm Owners Against Crime versus the City of Harrisburg. Representing the city is Miss Maureen McBride. Representing the firearm owners is Mr. Joshua Prince.
Good afternoon. The doctrine of standing requires that individuals must have a certain stake in a controversy in order to support their commencement of a civil action. Here, this court is asked to consider whether several firearms owners and an association representing their interests have standing to challenge City of Harrisburg ordinances regulating firearms. Ms. McBride.
Good afternoon, Your Honors, and may it please the Court. Maureen McBride for the City of Harrisburg, for Mayor Pappenfuse, and for Police Chief Thomas Carter. Your Honors, I'll get straight to the heart of our appeal. The plaintiffs in this case, 3 individuals and a political action committee, are asking this court to effectuate a sea change in Pennsylvania law on the issue of standing. Specifically, the plaintiffs are asking this court to lower the bar for standing to such a degree that any person, even a casual visitor or passerby to a municipality, can challenge the municipality's ordinances, even where the plaintiffs did not suffer any direct, immediate, or substantial harm, and where the harm complained of may never occur and is purely theoretical. The Commonwealth Court in this case clearly erred in reversing the trial court's dismissal of plaintiffs' claims on standing grounds with respect to 4 of the 5 ordinances. And I'll address it in a minute. The Commonwealth Court did correctly dismiss plaintiffs' challenge to the emergency ordinance, and plaintiffs have waived the right to challenge that ruling now. But the trial court in this case had it right. The plaintiffs failed to set forth sufficient facts in their complaint to establish standing to challenge these ordinances. And the context is important. The plaintiffs originally filed this action under Act 192 of 2014 and the automatic standing provision, but this court struck that act down on constitutional grounds in the Leach case. So plaintiffs are now trying to create standing from the bare bones allegations in their complaint, even though there are literally no facts to support it. And
Can I ask you a question, Counsel? Did this court bring the headache on itself in Robinson Township by allowing standing for people who experience, quote, unpalatable professional choices, unquote?
Well, Your Honor, I think the key word there is professional. I don't believe that this court's decision in Robinson Township controls the outcome in this case, or should allow the plaintiffs here to have established standing. This case, that was a very narrow exception in circumstances where a doctor in his professional capacity was faced with a Hobson's choice. He could either abide by the confidentiality provision or he could, properly execute his duties to his patients. There is no professional dilemma here. And
Hire his duties, just for the sake of argument. Can you explain to us why his professional duties are to be privileged over the exercise of other citizens' constitutional rights?
Your Honor, I think that the answer to that question is that this court, in limited circumstances, has allowed for pre-enforcement review of ordinances or laws. But there are facts that need to be pled in order to give rise to a finding of standing in those cases. In Robinson Township, again, in a very narrow circumstance, the doctor presented facts that said he could not execute his duty to his patients and also abide by the confidentiality agreement. And there are no facts in this case. I mean, in this case, the plaintiffs have not pled that any plaintiff here, all they've pled is that the plaintiffs either live in Harrisburg or travel to Harrisburg bi-weekly and own guns. They have not alleged that any plaintiff has been threatened with enforcement, let alone convicted of any crime. They haven't alleged that any plaintiff has even changed his behavior, and I say his because they're men, his behavior because of these ordinances. These ordinances have been on the books, some as long as 200 years, some 50 years, and I think the youngest is 10 years. They don't allege any facts whatsoever to create the Robinson Township unique circumstance where a professional obligation, again, owning a gun is not a profession, where they're faced with that kind of dilemma. And if you expand the doctrine of standing the way the plaintiffs are suggesting, there will be no barrier to entry. Anybody can sue for any ordinance, any law that they don't like or offends their sensibilities. They will have standing to challenge. If they live near a billboard.
Councilman, could I follow up? Instead of expanding standing, should we contract it? Did we create a de facto doctor exception in Robinson Township, which was unprincipled in some way?
Well, I do think that the Robinson Township decision is the only reason that the Commonwealth Court overturned its precedent in the NRA cases. I mean, it is solely because of that the court found that the plaintiffs here had standing. I leave it to the wisdom of the court as to whether the court should revisit that issue. But I think that stands in sharp contrast to the facts of this case. In the gaming board case, in the Yoakum case, again, a professional obligation where someone, had to make a decision to either abide by the rules in terms of applying, for jobs in the gaming industry and being able to actually, discharge obligations under their profession. Those facts aren't here. This complaint is totally devoid of any facts. I mean, we have, for instance, plaintiff Stolfer. They claim he's a visitor to the city. They don't claim he ever intends to discharge his gun in Harrisburg, in a park, in any unlawful manner. The same is true with plaintiff First. They claim he resides in Harrisburg. They don't plead any facts to identify any specific harm he's about to suffer. In particular, with the lost stolen ordinance, they don't say that any plaintiff expects to have his gun, first of all, brought to Harrisburg, let alone lost or stolen in Harrisburg, such that they would be subject to the ordinance. And in fact, what the plaintiffs have done in their brief and in their answer to the preliminary objections is to seek to add facts about the emergency ordinance, where they claim that the emergency ordinance, that one of the plaintiffs was actually in Harrisburg during an emergency ordinance. Those facts aren't even in the complaint, but even if they were, they're not sufficient to show that direct, immediate, and substantial harm. And this court, and I don't need to repeat it, but this court in the Pittsburgh Palisades case, William Penn parking case, has always said that the standard for standing requires direct, immediate, and substantial harm.
Excuse me,
Sure.
Justice Mundy, is it your position that your concerns would be alleviated if one of these plaintiffs had a conviction under one of these ordinances for the purpose of this lawsuit?
Well, Your Honor, I don't want to opine on facts that aren't presented to say what would or wouldn't be sufficient, because I do think that that's obviously something that would be vetted at the preliminary objection stage. But certainly those facts, if someone were convicted, would be a far cry from what's in this complaint. I mean, all the complaint here says is that the plaintiffs are subject to the law. And if that's the test, then everybody who drives a car, who is subject to speed limits, or everybody who is subject to any one of the,
Well,
hundreds.
these are a little bit different because it's raising a constitutional objection to the ordinance as opposed to a general objection to the ordinance. Isn't that a differentiation?
Well, I think, Your Honor, I mean, the issue of whether it's constitutional or the claim that it's preempted or any other claim that's a challenge to a law, we still have, as a matter of judicial restraint, the concept of standing in Pennsylvania. And if we don't have that barrier to entry, then we will, essentially bankrupt local governments and municipalities who will be faced with all kinds of challenges, constitutional and otherwise, that will divert money from, the money that should be spent on public works and for the citizens, and in defense of these claims. And our amici, I believe, did a great job of laying out those statistics about the number of lawyers and the amount of money that's already being spent in defense of cases. If we allow
Mr. McBride,
anybody...
may I ask a question?
Certainly.
But isn't there some tension between the traditional notions of standing and, the purpose of the Declaratory Judgments Act, which particularly our courts have said is to be liberally construed in their older cases? I think I pointed out at some point in the line that, talk about the Declaratory Judgment Act. Again, in order to obtain a declaration, it is not required that an actual wrong should have been done, such as would give rise to an action for damages, and no wrong need be immediately. Case from 1925 has to mean something.
Your Honor, I don't believe that the mere fact that this is a request for declaratory relief eliminates the standing requirements. As I read the cases under the Declaratory Judgment Act, there still needs to be a party, a plaintiff who is actually aggrieved, who has a direct interest, and that otherwise the court would be engaging in advisory opinions, which this court has said for years it's reluctant to do. So I understand the liberal application of the declaratory judgment rule, but there still has to be parties who actually have an interest, because if you don't have the right parties, you're not going to have the facts developed properly, and that actually harms people who do have claims that should be adjudicated.
Ms. McBride, I'm sorry.
I just wanted to follow up on Justice Mundy asked you about constitutional claims. And for purposes, as I understand where you are, an enforcement action is required to provide standing or something akin to that. I wonder if the standing analysis, in your view, is influenced by which constitutional right is sought to be vindicated. So, for example, instead of, if this was not right to bear arms, but instead a free speech claim, for example, time, place, and manner restrictions on somebody wants to hold a rally, that sort of thing, or a free exercise of religion claim, is our analysis on standing, in your view, the same? Or are you urging us to undertake a different standing analysis depending on which constitutional right is invoked by the plaintiffs?
Your Honor, I believe that the test for standing under the First Amendment traditionally has been more liberally construed, and that a chilling effect on speech, for instance, could give rise to a cognizable claim. I don't believe that test has been applied to other constitutional claims, including the Second Amendment claim. And to put a finer point on it, I mean, I'm not sure that we believe that there has to be an enforcement of the law, but certainly something more than I own a gun and I live or travel to Harrisburg. There has to be something more to show that these are the right plaintiffs to bring this claim at this time. And again, we're talking about, if we don't do this, it's going to open the floodgates, not just for municipalities who will have to defend, but also for the courts, because now anybody who wants to allege a constitutional claim can bring suit to challenge any law, no matter how old it is. Even if it's a 200-year-old law, you can go through the books and find an ordinance you don't like, bring a claim, allege it's constitutional, and have your day in court at the expense of everybody.
You would require, and I know Justice Guerra has a question next, but you would require the person that owns the gun and travels to Harrisburg, as I understand your argument, to suffer an arrest, and then he or she would have standing. Is that correct?
Well, I think if the person had suffered an arrest, they would have a much stronger case on standing to challenge a law that they've been, convicted under or arrested under, than somebody who just travels to Harrisburg and owns a gun, or travels to Harrisburg and brings a gun. I mean, these ordinances are specific. They they have specific requirements in order to find a violation. So, for instance, with respect to these plaintiffs, do they intend to bring their guns to a park? They don't say that. Are they minors?
It might be because they're being afraid of being arrested if they do.
Well, there are a lot of people who abide by the law and obey the law because they don't want to be arrested. I mean, that's a large swath of the population in Pennsylvania, I would hope, who abide by the law. And, standing is about
Even
lying.
a non-constitutional law.
Well, that puts the rabbit in the hat because we haven't even answered this complaint yet, but the argument of preemption or unconstitutionality is the plaintiff's argument. But that certainly has not been established here. I mean, right now
Justice Perez has a question.
Sure.
Sorry.
I do. But thank you, Chief Justice. Ms. McBride, I wanted to go back to Justice Weck's questioning. I saw this case as distinguishable, and I do use hypos to frame issues and to get concrete in thinking. I saw this case as distinguishable at first blush from Robinson Township, and I wanted to know if you disagree. So we have a 1905 ordinance that prohibits firearms in city parks. Assuming arguendo, hypothetically, that one of these individuals cut the grass in city parks and was now faced with the choice between his employment and violating the statute. It seems to me that that's the choice between practicing medicine as a physician and complying with the statute. So it seems to me that might provide standing. And I wanted to know if you disagreed with that. Do you understand my question?
I understand the question, but I don't believe that a person cutting the grass is required to bring a gun or that the gun has anything to do with the person's profession. I mean, it's a totally separate issue. In the Robinson,
the reality is, if he brings the gun, he violates the act. If he doesn't bring the gun, or if he insists upon bringing the gun, he's fired. The doctor doesn't have to practice medicine, I suppose.
well, I think the issue with Dr. Khan in the Robinson Township case was that he does have a duty to treat patients, and he did treat patients, and the facts in that case were that he treated patients who would come in contact with those substances. He could not serve two masters. He could not abide by the law and continue his profession. That's not true of, and again, there are no facts in this case that any plaintiff even works in the park or travels to the park.
Right.
But even if a plaintiff did, that's a far cry from the Hobson's choice that the Dr. Khan made. And this court in the past, in the Yoakum case and in other cases, the Cozen O'Connor case, it's always been with respect to professional obligations versus, your right to do something else. And so I don't see Robinson Township, and I don't anticipate that this court expected that Robinson Township was going to eliminate, decades of traditional standing analysis in this Commonwealth.
Thank you. Good answer.
I'll just briefly touch on the issue of the emergency ordinance. I mean, the plaintiffs lost that issue at the Commonwealth court level, did not file a petition for allowance of appeal. That issue is not before the court. And in any event, the Commonwealth court was correct to dismiss that. And I'll just briefly sum up. The Commonwealth court's decision should be reversed because, again, it will dramatically lower the bar to challenges to local laws, will open the floodgates to just purely theoretical claims. And it will wreak havoc on municipalities and local governments whose resources are already strained. And again, it harms those people who actually have claims and need the resources of the court. So we would ask your honors to reverse the Commonwealth Court's decision and dismiss the plaintiff's claims. Thank you.
Counsel,
Thank you.
it's just, may I just ask one question, Chief? Getting back to the Declaratory Judgment Act and the interface that we have in this case, My understanding is that this record supports the fact that it was the intention of the officials in Harrisburg to enforce the gun ordinances that are before us. And assuming that that's the case, the plaintiffs are gun owners who are living under the uncertainty of whether or not their exercise of their right to bear arms is going to be put at risk if they're within the city of Harrisburg. Doesn't the Declaratory Judgment Act specifically anticipate that that type of uncertainty is what is meant to be addressed within the context of the Declaratory Judgment Act?
Well, let me just go back to the premise of the question, because the plaintiffs cite statements by the mayor, but the statements are vague references to the ordinance. They do not indicate in any way an intent to immediately enforce the ordinances, and certainly they don't show an intent to immediately enforce the ordinances against these particular plaintiffs. He merely said that the ordinances would not be repealed, and that he believed that the ordinances were sensible. These statements are about the utility of the ordinances, not a threat of enforcement. So with respect to a declaratory judgment action, again, the standard, as I understand it, for declaratory judgments is that you still need to have essentially a case in controversy where you need to have some threat, something likely to happen, immediate harm that you're asking the court to give you guidance on so that you're not falling into a trap. That's not the situation here. Again, because we're a fact pleading state, we're back to the facts of the complaint, not the, what the plaintiffs perhaps wish they had pled, but what they actually pled in the complaint. And it is as bare bones as I've seen, and it doesn't give rise to any controversy other than they don't like these laws. They don't even say what would happen. I mean, they don't like the laws and they think they should, I don't know what, be repealed, but they don't have an active controversy that this court needs to decide.
We don't have controversy in our Constitution.
I understand.
The Constitution has one.
I understand, Your Honor, that it's not a jurisdictional issue, but certainly this court has required that the plaintiffs have a stake in the outcome and that they have something imminent. And that's what the Commonwealth Court had held in the NRA cases. It had said that the plaintiffs did not show that it was likely that they would face enforcement or threat of enforcement. And that's, to me, the wiser course, because those are the right people to bring those cases at the right time.
Unless you would say there is either a professional or pecuniary interest that's impacted from the plaintiff's perspective. Is that to limit standing? Or that is what our law currently requires?
I think under Robinson Township, I think it was because there was a professional dilemma
it's not only Robinson Township. That wasn't pulled from thin air. Shawless preceded the case involving the coal industry preceded
the Arsenal,
which of course was not a professional impact. That was purely a pecuniary impact on a company that worked in the industry. So you're saying our jurisprudence calls for either a professional or pecuniary impact?
I think that's fair. I think that's fair.
Could I probe along those lines for a moment, counsel?
Sure.
Supposing that is where we are, should that be where we are? The question is this: can you tell us why, in principle, we should prefer or privilege those with professional or pecuniary interests over those who merely want to vindicate their constitutional rights, whether those are to bear arms, to speak freely, to exercise their religion, for reasons that have nothing to do with profession or pecuniary? What's the principal basis for that that you should think we should apply going forward?
Well, Your Honor, I'm not sure that that the court has explicitly said it must be pecuniary or professional. I do think that that is how the case law has evolved. And I think the reason for that is because those people have claims where they are facing a specific dilemma that involves their profession or their pecuniary interest. The case that Justice Donahue referenced, the Arsenal Coal case, had to do with regulations and whether the company could comply with those regulations. And so to me, it's more about the facts of the cases and the dilemmas that have been faced rather than whether they're professional or pecuniary. So I don't think that, it's out of the realm of possibility that somebody could challenge an ordinance that doesn't affect their pecuniary or professional interest and still have standing. But I do think the way the cases have evolved is because those people and those companies have faced dilemmas that have required guidance from the court.
Thank you. Thank you, and we appreciate that. Well, Mr. Prince.
Good afternoon, Chief Justice Saylor and Justices of the Court. May it please the Court, I'm Attorney Joshua Prince, and I represent the appellees in this appeal involving the standing of appellees to challenge several unlawful ordinances regulating the possession, transport, and use of firearms enacted and enforced by appellants in direct defiance of Article 1, Section 21 of the Pennsylvania Constitution, 18 PACS Section 6120, and the legion of binding precedent, including this court's decision in Ortiz v. Commonwealth. There is no dispute that the ordinances are currently being enforced and that the appellees are subjected to them. Appellants also don't contend before this court that their ordinances are lawful. Rather, appellants seek to force Hobson's choice on the appellees, either comply with the ordinances or be prosecuted pursuant to them, thereby pitting a fundamental right against these unlawful ordinances. But it doesn't end there. Appellants seek to prevent appellees and everyone else from ever being able to challenge their unlawful enactments on the grounds of standings. If appellees declare that they're violating the ordinances, appellants will prosecute them based on their own admissions. And then when they attempt to argue that the ordinances are unlawful, they'll argue that they cannot seek relief because they come to the court with unclean hands. If appellees declare that they aren't violating the ordinances, they'll contend there's no case or controversy. And if appellees declare that they intend to violate the ordinances, appellants will contend that such is probable cause to harass them, and if during a search they're found in violation of an ordinance, they'll then prosecute them and again claim that they have unclean hands for any challenge. Appellants' arguments are tied up in a nice, neat bow to prevent any review ever of their unlawful ordinances. This is exactly why this court has consistently held in Arsenal Coal, Robinson Township, Yoakum, and numerous other cases that pure questions of law are particularly well suited for pre-enforcement review under the Declaratory Judgment Act. And we believe we've sufficiently average standing in this matter. But to the extent the court disagrees, we've requested an opportunity to file an amended complaint consistent with the holdings of this court. Now, I understand that my initial opening statement time is about to elapse, and I'd be happy to take any questions that the court may have. But I would respectfully ask, of course, with the court's permission, to be able to address the 5 Beaster factors for taxpayer standing if the Price decision is no longer good law, since appellants only raised the issue in their reply brief and we haven't had opportunity to respond. Thank you.
Mr. Prince, Justice Baer, are you saying that your clients have substantial direct and immediate interest and are therefore aggrieved? Or conversely, are you saying we should get rid of that standard?
Your Honor, we have argued in the alternative for both. First and foremost, under the Declaratory Judgment Act and consistent with Chief Justice Saylor's dissent in Palisades, we believe there should be a lesser standard under the Declaratory Judgment Act for standing. That being said, we also believe that we have averred under our complaint sufficiently enough for traditional standing that we've shown a direct, substantial, and immediate interest in challenging these ordinances, including if the court looks at the zone of interest that is sometimes employed in relation to the immediacy. And when you look to the zone of interest analysis that this court has put forth, it suggests that whenever there is a constitutional or statutory provision that would prevent or otherwise invalidate the challenged or ordinance or law, that is of an accord that this court should absolutely find standing, because those issues are of such paramount importance that they need to be addressed.
And how do you limit your holding, your desired outcome, so that it does not give every resident the opportunity to challenge every law that they, in good faith, disagree with?
First of all, this involves a fundamental constitutional right, which is distinguishable from just any other generalized issue. Secondarily, the person still has to show that they're subjected to the law and have some relationship to the law. In this case, all of the appellees are subjected to it, and they own firearms whereby these ordinances apply to them. If they were to aver additional facts consistent with violating the ordinances, as I alluded to earlier, then they would be prosecuted for violating those ordinances, and their own admissions that they're violating the ordinances would come in against them, and appellants would argue they have unclean hands.
Mr. Prince, I'm not sure I agree with that. I mean, certainly someone that's arrested could assert a constitutional claim against the statute under which he's arrested, and nobody's going to say he has unclean hands. So I don't quite apprehend that argument. Back to the standing, although our Constitution doesn't have a case or controversy requirement, we borrowed to a large measure the federal jurisprudence on standing. And I know our U.S. Supreme Court said very recently they don't want to hear any more facial challenges to statutes. They were only interested in as applied challenges. So there is a legitimate argument to make that you're really mounting a facial challenge to the statute. And the only question for this court is that as of one in a declaratory judgment act.
Your Honor, I'm not sure which U.S. Supreme Court case Your Honor is referencing. I'm not aware.
About 2 years ago, they said we're kind of getting away from this thing of facial challenges. We're only interested in as applied challenges. I can't tell you the case.
And I'm sorry, Your Honor, I don't know which case you're referencing. I'm unaware of the U.S. Supreme Court coming down with a decision in that regard that would basically prevent where there is general application. It's not.
Well, that's their decision, not ours, but I'm just telling you that's their move.
Understood, Your Honor. And again, we didn't just aver under traditional standing and under the declaratory judgment where we believe there should be a lesser standard. We also contend that we have taxpayer standing. And as I alluded to in my initial opening statement, to the extent the decision of this court in Price is no longer good law, we do believe that we've established under Beaster and Palisades that we do have taxpayer standing. And in fact, setting forth the 5 factors in relation to the first, that the ordinances would otherwise go unchallenged. In this matter, individuals cited for violations of the ordinance do not generally have the inclination or ability to spend tens of thousands of dollars challenging such ordinances when the fine in comparison is very minimal. In relation to the second factor, the ordinances benefit the appellants as a revenue generating scheme and permitting them to impose their political beliefs upon the residents of Harrisburg. And therefore, appellants aren't inclined to challenge their own enactment, and the residents of Harrisburg in general are also not likely to challenge it, as a revenue generating scheme reduces the potential for tax increases. In relation to the third factor, judicial relief is clearly appropriate, as this court in Ortiz, pursuant to Article 1, Section 21 and 18 PACS Section 6120, already declared that municipalities may not regulate firearms and ammunition. In relation to the fourth factor, there are no other viable channels for challenging the ordinances other than criminal prosecution, which is not required for an individual to challenge an enactment consistent with this court's holdings. And in relation to the final fifth factor, appellees are best suited for challenging the ordinance as they're adversely affected by them and have the requisite financial backing and aptitude to challenge them. So whether we review this under if we review this under the Declaratory Judgment Act with a lesser standard, whether we analyze it under traditional standing requirements or taxpayer standing requirements, we believe we've met all of those requirements to establish standing to challenge these unlawful ordinances.
Mr. Prince, could I jump in with a question about the history? I did not see in the papers that that leave was sought to amend to supplement the factual averments. Am I correct about that?
Your Honor, we did request it in our answer to the preliminary objections, asking that if the court was going to grant preliminary objections, that we be afforded an opportunity to amend. The court then issued an order dismissing the case without providing us with an opportunity to amend.
But given that the order, at least the one that I saw, sir, did not say sustained with prejudice, why wasn't leave sought as of right?
We believed we had preserved the issue by including it in our request. Respectfully, Your Honor, I'm not sure how many times an individual, whether it be a plaintiff or a defendant or such, has to request a certain relief before the court before it's sufficient enough. And the decision that was rendered by the court was somewhat questionable because the decision rendered by the court said that we were seeking automatic standing under Act 194, which was not the case. And the trial court decision never analyzes any of the averments in our complaint and how we have requested traditional standing or averred at least traditional standing as well as taxpayer standing, even though all of those arguments were made consistently throughout the complaint and through the preliminary objections and responses thereto.
Counsel, this is Justice Donahue. Let's get back to traditional standing, and maybe I could test with you what the outer limits are from your perspective. Let's say the plaintiff is a resident of Harrisburg who is considering purchasing a firearm and wants to do so. But because of these ordinances, feels that they would be in jeopardy by doing so. Do they have standing?
I think in that situation, it may be too attenuated. Obviously, it's going to depend on the exact situation and which ordinance we're addressing and whether it's a hypothetical ordinance that may impose some sort of restrictions on the purchase of firearms versus once someone already has that firearm. I think that's consistent with some of this court's decisions previously, such as the, I'm forgetting which case name off the top of my head, where the entity had not even yet applied for a license yet, a gaming license, and said that they were only a potential gaming licensee applicant. And the court there in that case found that they did not have sufficient standing in order to challenge it. And I believe that actually that was in the Palisades case.
Yes, it was. But the hypothetical that I've given you implicates the same constitutional right that your clients are attempting to vindicate. From your perspective, does your view of standing go as far as my hypothetical Harrisburg resident who would like to purchase a firearm, but because of these ordinances is not doing so?
I believe whenever a constitutional right is in jeopardy or is being questioned, that would be sufficient enough standing to seek redress in the court for those rights to be declared, especially under the Declaratory Judgment Act, where that is its purpose. That's why the General Assembly enacted it.
Thank you.
Thank you, Mr. Prince. Thanks, Ms. McBride. So that will conclude argument in this case, and we'll take a 5-minute recess and then call the next case.
Thank you.
The next matter is Commonwealth of Pennsylvania versus Carlos Perez. Representing the Commonwealth is Mr. Matthew H. Davis. Representing Mr. Perez is Ms. Terry B. Heimbaugh.
Good afternoon. In this criminal case, the victim was killed at a nightclub by a knife wound to his neck. Aplt was charged with first-degree murder. At the preliminary hearing, the municipal court dismissed the suit for lack of evidence. The Commonwealth refiled the case the following day. The Common Pleas Court presided over the second preliminary hearing and again dismissed the prosecution, finding that the Commonwealth failed to introduce sufficient evidence to proceed to trial. The issue in this appeal is whether the Common Pleas Court applied the correct standard of evidentiary sufficiency regarding the Commonwealth's burden at the second preliminary hearing. Mr. Davis.
Thank you, Mr. Chief Justice. Good afternoon, Your Honors. May it please the Court. My name is Matt Davis, attorney for the Commonwealth. As you said, Mr. Chief Justice, this is the Commonwealth's appeal from a preliminary hearing where the Commonwealth presented direct eyewitness testimony to support its charges of murder against defendant. To be clear, the evidence that the Commonwealth presented at this preliminary hearing was not circumstantial. It was not hearsay. It was direct eyewitness testimony of multiple witnesses who were on the scene. Specifically, the Commonwealth presented the testimony of Mr. Marquise McNair, who was a security guard who testified that he personally witnessed defendant and the victim in two separate fights at a nightclub. Mr. McNair broke up the first fight between defendant and the victim and then kept watch over them so that he was watching when they began what he described as a second and more violent and aggressive fight. As Mr. McNair went over to break up the second fight, he saw defendant reach his hand towards the victim's throat in what Mr. McNair described as a punching motion. He then went over and was attempting to pry the two men apart when he noticed that the victim was gushing blood from his throat. A bystander then yelled out that, quote, "they cut him," at which point the victim ran out of the club and collapsed and bled to death from his throat outside the club.
Could I interrupt, counsel? Speaking only for myself, I think we all know the facts. The question is whether it's direct, circumstantial, or both. It's definitely an inferential, right? Well, put it this way. Here's the question I'd like to ask you: is doesn't the court have to assess the reasonableness of the Commonwealth's inferences before it goes ahead and views them in the light most favorable to the Commonwealth? If that's true, what would that reasonableness analysis look like? Wouldn't it look something like what the Superior Court did here?
To answer your first question, Justice Wecht, I think that the way I understand the standard is that the court views all of the evidence in the light most favorable to the Commonwealth, and has to accept the Commonwealth's evidence as true. And then having done that, the lower courts are bound to draw all reasonable inferences in favor of the Commonwealth. And this court has defined reasonable inferences as being more likely than not. So that's what I understand the standard to be. And moving on to the second part of your question, the Commonwealth's argument here is that the Superior Court majority did exactly the opposite of that and drew inferences not only not in the favor of the Commonwealth, but actually in the favor of the defense. And there's many instances where we can read through the opinion and see where the Superior Court majority did that, and then look to the record and see how the record rebuts those inferences that they drew as being Commonwealth favorable. So moving through the opinion, for example, this notion that anyone could have stabbed the victim and that this was some type of melee or brawl where it's impossible to know who actually stabbed the victim's throat, that is simply not on the record anywhere and could only be reached, as the Superior Court dissent noted, by drawing inferences in defendant's favor. What is actually on the record is that Mr. McNair, who was a security guard at the club, as I said, was adamant that only defendant was engaged with the victim in the fights that they were having. Now, whether or not there were other fights going on around them, or if there were other members of their respective groups involved, is not entirely clear from the record, but it doesn't need to be. That's just a distraction from the fact that Mr. McNair came into court and testified that he saw defendant and only defendant fighting the victim, and then defendant reaching out towards the victim's throat before it was slashed. So I would argue, and it's the Commonwealth's argument, that the only reasonable inference from that is that defendant was the murderer. To say that anyone else could have murdered him would require a defense-friendly inference.
Counsel, it's Justice Donahue. In follow-up to this discussion, do the courts have to ignore the fact that there were 15 to 20 people in the vicinity and there was no actual witness to the stabbing?
No, the courts don't need to ignore that.
Isn't that what the Superior Court took into account? Not to mention the two other courts who found insufficient evidence for this case to go forward. I mean, there are essentially three courts who said there wasn't enough here to get to the jury.
Yes, Your Honor, there were. And in response to that, I would just simply say that this is de novo review, and this court is the final arbiter of legal questions in the Commonwealth. And to say that a case can never come before this court if all the lower courts agree, I think would deprive this court.
And that's obviously true, counsel. But back to my more precise question: do the courts have to ignore what were essentially uncontroverted facts? There were 15 to 20 people in the vicinity, and there was no witness to the stabbing. You had a witness who testified that the defendant reached toward the victim in a punching motion. But did the courts have to ignore that background, that evidence that surrounded the Commonwealth's evidence?
No, the courts did not have to ignore that. I would argue that those facts are, at least the number of people in the area is irrelevant and could be ignored, but it's certainly something that could be taken into account. But I would push back a little bit on the notion that it was uncontradicted how many people were in the area. Mr. McNair.
20 is a low number, correct? The defendant suggested there were more people in the area.
Right. There was.
I was taking your number.
Okay. After a long cross-examination, Mr. McNair finally settled on what he said was between 5 and 15 people, but it wasn't clear if that referred to each group or the total number of people. What we do know is he said that there wasn't a crowd, and that he actually earlier in the testimony said that there were not as many as 5, 10, or 15 people in the area. So the number of people in the area is disputed, and I think this really gets to the heart of the issue, that the Superior Court kept adopting inferences in defendant's favor because it was treated as a foregone conclusion that there was this number of people when that isn't clear from the record. Now, in terms of no one witnessing the stabbing, it's certainly true that Mr. McNair testified he did not actually see a knife go into the victim's throat. But the preliminary standard, the Commonwealth's burden at a preliminary hearing is relatively low, and it can be met through circumstantial evidence and is met that way all of the time. And so what we have here is an individual who's testifying that he sees defendant, who had already been fighting with the victim, reach out towards the victim's throat. He didn't see the exact impact of a knife or some other implement on the throat, but then he immediately sees the victim's throat gushing blood. And keep in mind that these two men are interlocked, fighting each other. So that evidence is sufficient to arrive at the conclusion that only defendant could have been the one who stabbed the victim.
Mr. Davis, it's Justice Fair, and let me stop you because I think that might be a sufficient inference. Again, it's always hard to divine what a different judicial figure did, a different judge or trial court. But the evidence here, again, it's unfortunate we're talking evidence, but the evidence here was that McNair broke up the fight the second time. which put him much closer than nose to nose, and put him right in the middle of the melee. Broke up, saw the fist or the hand go up toward the neck, broke up the fight a second time, and then thereafter, a woman in the crowd shouted, "They cut him," or the like. So what I think perhaps was driving the lower courts is precisely the opposite of what you said, which is when McNair broke the fight up, the guy's neck, his jugular is cut. One would think blood is spewing about. Indeed, he bled out on the scene, so it was a profuse bleeding. And yet the individual who broke the fight up, at the moment he broke the fight up, didn't see any blood. And I think that's not an inference against you, that's a fact against you.
I don't have the same reading of the record. I think that Mr. McNair did testify to seeing blood. I would point your honors to the Commonwealth's reproduced record, page 53A, where Mr. McNair said, quote, "I thought he just got punched in the face and then he took his hand off his neck and blood was just gushing out." So I think certainly maybe in a dark nightclub, the fact that someone yelled, "They cut him," could have had something to do with his conclusion that that the victim was cut. But there is evidence on the record that McNair saw blood coming from the victim's throat. And so to say that no one, quote unquote, saw the stabbing, I think is being a little too specific. It's true that no one saw a knife enter the throat, but McNair's testimony certainly leads to the reasonable inference that the defendant stabbed the victim.
Thank you. We'll have to check the record.
Okay. And this all comes down to the record, and it's, we cite in our brief the places where it's clear that McNair saw this happen. And that's not the only instance where the Superior Court was adopting these defense favorable inferences. There's also the question of defendant's actions after the stabbing, where he exited the club at first and then retreated back in after he was punched by the victim's friend, and then took his shirt off and hid it in places twice before lying to a police officer that he hadn't been in a fight. Now, whether or not that is sufficient to prove his guilt, I'm not necessarily saying that. But what I am saying is that one could only say that that's cooperating with the police by viewing that evidence in the light most favorable to the defendant. I think that that's evidence of the Superior Court's confusing the standard here and applying the wrong inferences, because there's just, I don't see how you can consider that evidence and come to the conclusion that it demonstrates that defendant was cooperative and staying on the scene.
Mr. Davis, as you can tell from the questions, we're intimately familiar with the fact that we view it as a purely legal issue. Maybe I'm wrong, but it's not the standard, the preliminary hearing, whether there's evidence that a crime committed and some evidence to link the defendant with the commission of the crime.
Yes, that's correct. I think probable cause.
And your argument is we met that standard.
Yes, absolutely. The elements of murder are, I'm sure your honors know well that someone was killed. The defendant was probably the perpetrator, and defendant acted with malice and specific intent. Those are the elements.
Now you're going to have to prove all that to a jury. You just want to get beyond memory.
Certainly, and I mean that's really what this comes down to, is defendant will have the opportunity to raise all of these defenses to a jury about whether McNair saw what he said he saw, or where's the murder weapon, etc. But that is not the standard at the preliminary hearing. A witness could get on the stand at a preliminary hearing and say 3 sentences, each of which meets those elements, and the Commonwealth has met its burden, regardless of what other contradictory evidence there is. And so here, it's clear that each element of each element of murder that I just described was made out. And actually, everyone agrees that it was made out, except for whether defendant was probably the perpetrator. And as I said, the fact that McNair gave all of that testimony that I went through and saw blood gushing and saw his arm go to the victim's throat where the victim bled from, is sufficient to show the defendant was probably the perpetrator.
Thank you.
I would just say that I guess that's all I really have, unless your honors have any more questions for me.
Thank you, Ms. Heimbach.
That would help. May it please the court, my name is Terry Heimbaugh. I represent Mr. Carlos Perez. I respectfully disagree with a lot of the inferences and the statements that Mr. Davis has indicated were fact and of record. And I think it's important to note the timing of this. There was an initial altercation, a pushing match, where Perez and the victim occurred, and it was immediately stopped. And then 2 minutes later, there was this second pushing match. And there was enough time between the McNair separating Hazelton and Perez in that second pushing match for him to actually separate them and to take them apart. It was 2 seconds later, just 2 seconds, that the woman screamed, "They cut him." Now, of course, we don't know who the woman is because no one identified her or had her brought in to testify. But it's really critical to note that McNair testified that he had been facing the victim when he heard the woman scream, and that he could see the victim very clearly. Now, McNair testified that when the female screamed, he did not know where Perez was, and that's notes of testimony, April 5th, page 72. So he's facing the victim. He's looking at the victim. He could see the victim clearly. They were separated 2 seconds before this, and yet McNair can't say he knows where Perez is. Now, the two groups, I think it was pretty clear that there were two groups totaling 10 to 30 people in total that were involved in this. And this is a very tiny, tiny club. Also a very dark, dim club. It was blue light. Not a lot of space to move around, not any space between the booths and the dance floors. One is right up against the other. Now, McNair didn't hear any glass breaking. No weapon was ever recovered by the club. And the most that McNair could state was the, quote, the Spanish male coming at the decedent in the area where his neck would have been. And that's notes of testimony, April 5th, page 76. McNair didn't testify to actually seeing Perez's hands at or near the victim's neck, only the arm movement. Now, most that he could identify was the arm movement by the neck. Any movement seen in a crowd of 10 to 30 people without evidence of an actual weapon being seen, especially given that McNair had to be still pretty close. If he saw the victim, he could see the victim very clearly, saw the blood coming out of the victim's neck, he would have been able to see that weapon if it had existed. He would have been able to see Mr. Perez, even if Mr. Perez was trying to get away at that point, because he was in the general same very close vicinity. Now, Martinez didn't see the Spanish male get close to the victim at all during the second pushing match. And there are a lot of people, he testified, Martinez testified, there were a lot of people in between he and the victim. The Commonwealth didn't produce any of the video footage, if there was any, from the cameras in the club, which there were. And there was no evidence of any motive. In fact, McNair testified that both Hazelton and Perez told him after the first pushing match that they're cool, they're friends, no problem.
Ms. Heimbaugh?
Yes.
Can I interrupt you for a second? I wanted to let you make your opening, but it seems to me that your presentation respectfully makes the Commonwealth's case. It's a case of inferences, and you're arguing all the inferences favor your client. That may be so, but that's not the legal standard that we apply at this juncture of the case.
My argument is that if you look at them neutrally, if you simply look at, could McNair, standing where he's at, could he see Perez, or should he have been able to see Perez? Should he have been able to see the weapon? That is an inference that's not an inference that goes one way or the other. That is a fact. Could he see it? Well, if he says he was standing and looking at the victim, he should have been able to see it. Yes, he testified he couldn't see it.
Well, he testified, and I don't want to nitpick about it. We're going to have to read the record on, in my question for the district attorney, he contradicted the evidence as I read it in the Superior Court's opinion. And that's okay. I mean, the record will say what the record says. But what we know, I think, and tell me if I'm wrong, we know that McNair, he's the bouncer.
Yes.
That he breaks up the second fight, and there's no, well, there may be, that there's no question he never sees a knife, never sees a bottle, etc. But he may have, he never saw blood. Or did he see blood?
No, he did. Actually, McNair testified that there was lots of blood on the floor. April 5th, page 74. He had no idea how many people had gotten blood at them, yet he also said that he saw blood on the other bouncer's suit.
Let me interrupt you. We're talking right now at the moment. There's a 5-second span. Hand comes up toward the neck area. Fight's broken up. A woman yells, they cut him.
Correct.
Where in there did McNair see blood?
No, he didn't see blood until after the fact, where he saw that there was blood on the floor in that area, lots of blood on the floor in that area, so much so that Big Mac, the other bouncer, got blood on his suit, and Big Mac was not even there. He was fairly close, but not as close. So Mr. Perez, the evidence shows that the shirt that Mr. Perez was wearing, which is the reproduced record Commonwealth's R30A and RR83A, show only 2 fist-size blood spatters on the chest and one close to the arm. Not nearly what one would presume if someone has cut your carotid artery and is gushing out and you're that close, that you're able to stab him and you're still that close, that should have spurted out and covered him. But that's not the case. And that goes along with the fact that McNair didn't see Perez when he turned and saw, after he heard the woman say they cut him. He did not see Perez even though he saw the victim with the blood. So that would be consistent with it.
Counsel, this is Justice Dougherty. I have a question for you. You seem to be restricting your argument to the act in and of itself, but this is a prima facie showing in which more likely than not a crime was committed and your client committed the crime. Now, taking into consideration the fact that your client left the facility, hid his shirt, found the shirt, was not truthful to the police officers, taking that all together for a prima facie level, not beyond a reasonable doubt. How do you argue that the Commonwealth has not met its burden when you take the facts most in light?
Well, I think if you look at the facts, first of all, it's a misstatement of the facts and it's an unreasonable inference to draw. Perez did not attempt to leave the Blue Martini or sneak out. He had 5 different opportunities to leave if he had wanted to. McNair testified that immediately after the incident, he and the other bouncers emptied the club out of all the patrons, including Perez. And that's at page 36 and 39 of April 15th. Perez could have left the area at that time, but he didn't. Martinez, who had gone outside, testified that as he was re-entering, he saw Perez standing just outside the front door, standing there. Now, he didn't leave. He didn't run off into Old City as he could have. He stood there. Perez had a second opportunity then to leave, and he didn't. He then went back inside the club to the bathroom, which was in the back of the club. The third opportunity when he went to the bathroom at the back of the club to leave the club. Theoretically, could lead through the back or the front.
Is that counsel? Is that the moment that he removed his bloody shirt and hid it?
When he was I would take issue with the fact that he hid it. What he did is he took his bloody shirt off after he had been punched and he put it in the trash can. That's not the act of someone who's trying to deceive and to hide. If he wanted to hide it, there's a lot better places that one could put it that would conceal it than in the trash can, which would be, frankly, the first.
So, counsel, these are all wonderful arguments for a jury, but we're at a prima facie level. So thank you. I appreciate your answers.
Your Honor, I would just add that he had 5 separate opportunities to leave, and he didn't. Most notably, he was left alone in the club after he came back from the bathroom with the shirt over his shoulder, with the evidence over his shoulder. He sat down in the booth and he waited, and he sat there. He could have, because no one was there. McNair said when he took him back to the booth, there was no one else left in the club.
I appreciate that, but credibility and intelligence are not at issue at a preliminary hearing, as whether he kept a piece of evidence over his shoulder. So we're not challenging his intelligence. We're just questioning whether, as the facts as seem most light and favorable to the Commonwealth, a crime was committed and your client committed the crime. And I think you've answered that very well. Thank you.
Yeah, I think you've done an able job. Go ahead, Justice Wax.
Could I just follow up briefly?
Yeah.
In listening to your answers to my colleagues, I have to ask you, isn't the very granularity of your responses itself the best indication that these are quintessentially jury issues?
I don't think so. I think that if you look at these as the justices did, and you have to note that this was, as the court pointed out, this was not just one judge or 2 judges. This was Judge Gerhardt, Judge Streeter Lewis. There was actually a total, by all said and done, of, I believe, 5 judges who all looked at the same evidence, who all are well aware of what the burden for a prima facie case is, who all determined that, in fact, there was not a prima facie case. Now, hypothetically, while one of these judges might have misapplied the law, maybe even 2 of the judges misapplying the law, it's clear that the 5 of them looking at this said no. In fact, there is not enough reasonable inferences. And the head note is, what is reasonable inference? There's a difference between just an inference and what is a reasonable inference. And we believe here that the Commonwealth did not draw reasonable inferences.
Thank you.
Thank you.
You've been an able advocate for your client in 3 forums. So
Thank you.
with that, we'll take a 5-minute resource and call the final case.
Thank you, Your Honors.
Thank you, Your Honors.
The next matter is Corey and Linda Donovan versus State Farm Mutual Automobile Insurance Company. Representing State Farm is Mr. Michael Salzberg. Representing the Donovans is Mr. James Haggerty.
Good afternoon. This auto insurance matter arises from the certification of a question from the Third Circuit. A motorcycle driver was injured in an accident and obtained underinsured motorist benefits under his own policy. He then sought stacked UIM benefits under a separate policy maintained by his mother, with whom he lived. The primary issue focuses on whether his mother's waiver of stacking in relation to UIM benefits applies across policies. Other issues pertain to the validity of a household vehicle exclusion and a coordination of benefits provision in the mother's policy. Mr. Salzberg.
Thank you, Mr. Chief Justice. May it please the court. The three questions that you've agreed to respond to at the request of the Circuit Court of Appeals starts with the first question is, and this is the only question I'm going to focus on, and I'll tell you why in a minute, but it asks you basically to engage in statutory construction, and to decide, did the legislature promulgate the waiver form in section 1738D2 to constitute a rejection of inter-policy and intra-policy stacking, or only intra-policy stacking? If you answer the question that it waives both inter and intra-policy stacking, your response to the first question of the Circuit Court would be yes, and would be make it unnecessary for you to respond to the other two questions. And I'm going to focus the argument only on the first question for two reasons. One, I am reasonably confident that you'll agree that the legislature intended the waiver form to constitute a rejection of both inter-policy and intra-policy stacking. And the second reason I probably shouldn't even address, well, I'm not as nearly as confident as to the other two issues if I lose the first issue. So in determining the legislature's intent in promulgating section 1738D2, you need to look at a little bit of the legislative history. Now, this is 1738 is now part of the financial responsibility law that was enacted in 1984. And one of the reasons it was enacted was to curb the escalating cost of insurance. 6 years later, the legislature promulgated the Act 6 amendments. And the Act 6 amendments were promulgated because the original statute wasn't doing such a great job in controlling the cost of insurance. And under these Act 6 amendments, the legislature was giving named insureds various options that they could elect to reduce the amount that they were paying for automobile insurance premiums. And those options included becoming limited tort as opposed to full tort, the rejection of uninsured motorist coverage in section 1731, or the rejection of underinsured motorist coverage, and then in section 1738, to those who continue to opt to purchase uninsured and underinsured motorist coverage, the option to lower the premium by at least rejecting stacked limits of coverage. And the cases interpreting the financial responsibility law from this court, go backwards and forwards. The legislature intent, the insurance company always argues, is to curb the escalating cost of insurance. The injured people say it's for remediation purposes, but not for the purposes of 1738. It's clear, it's admitted in the brief of the Donovans. The reason that 1738 and the other Act 6 amendments were promulgated were to give insureds the option to reduce their premium. And I submit to you that by interpreting the statute to waive both, the statutory form to waive both inter-policy and inter-policy stacking, that's going to give more premium relief than if you interpret it to just to reject intra-policy stacking. And if you look at what you've decided already, you've decided in the Craley case that inter-policy stacking could be waived. And there was some issue, the way 1738 was written, it wasn't a modicum of clarity, but this court in the Craley case, and with all 6 justices agreed that that 1738 required that insurance be given the option to waive inter-policy as well as intra-policy stacking. So my 3-part analysis is, number 1, insurers are required to give insureds the option to reject both types of stacking. Number 2, the legislature only promulgated one form for named insureds to reject stacking. And in the statute, it says itself, before the form, it says, the named insured shall. Okay, so the named insured is required to be informed that he may exercise the waiver of the stacked limits of underinsured motorist coverage by signing the following written rejection form. And this doesn't talk, it's not limiting it to intra-policy stacking. It's not limiting it to inter-policy stacking. It's talking about stacking that you've talked about earlier in this section, where you said the court has already found that the purpose of this statute was to give insurers the option to reject both types of stacking. Now, keep in mind, before the Act 6 amendments were passed, okay, between 1984 and 1990, named insureds were required to purchase uninsured motorist coverage and underinsured motorist coverage, and they were required to purchase equal limits of the coverage. As a result of these Act 6 amendments, named insureds were not only given the option to reject the uninsured motorist coverage and or underinsured motorist coverage entirely, and of course they could get more of a reduced premium, but they were given the option to reject stacked limits of coverage that would also reduce their premium, but not as much as they rejected the coverage in its entirety. So the purpose of the statute is to provide premium relief for those who opt to elect to reject stacked limits of coverage. The legislature requires the insurance companies to give the option. They require insurance companies to use this particular form for insureds to reject stacked limits of coverage. And in every option under Act 6, under the Section 1731, for the rejections of uninsured and underinsured motorist coverage, the legislature promulgated forms that must be used if there's going to be rejection of uninsured or underinsured motorist coverage. When the legislature amended Section 1705 to give insureds the option to become limited tort, they gave forms, these option forms that they're required to use if for insureds to choose between limited tort and full tort. And there's also an agreement that under Section 1738, at least the legislature promulgated a form that the insurance companies are required to use for an insured to waive intra-policy stacking. And I respectfully submit, would be unreasonable to assume that the legislature decided, okay, you're required to give them the option to reject underinsured inter-policy stacking. You're required to give them the option to waive inter-policy stacking, but we're not going to give you a form to do that. We're giving you a form for everything else.
Mr. Salzberg.
Could I ask you a question on that? Didn't this court say in Craley, specifically on page 542, footnote 18, that the reasoning would not apply in a case like the one before us today, where there's more than one vehicle covered? Isn't that an important distinction? Don't you necessarily need us to overrule Craley to prevail on this question, particularly given that nobody, not the General Assembly, not the insurance commissioner, not the insurance industry, did anything to deal with this anomaly in the language? You know, like Chief Justice Cappy said about changing it to say policy or policies. Nobody did a thing. And here we are again.
Well, Your Honor, I respectfully disagree that the court made any holding in Crayley as to what the court did in that footnote, questioned whether the same rationale would apply if there was a multi-vehicle policy. But that was not the issue before the court. That was not the issue that was briefed. That was not the issue that I understand was argued. But certainly, Your Honor is correct that in the majority opinion in that footnote, they had problems as to whether or not, if it was a multi-vehicle policy, that the rejection form was sufficient to reject inter-policy stack. I have no problem with that. I would like to make a correction to our brief and our reply brief on the second page of the.
Justice Baer, before, and again, I don't want to constrain your answer, but if you're beginning to make a correction to your brief, we'll absolutely let you do that. I don't want you to get too far afield of where Justice Weck is, because I think it's the thrust of the case. And I wrote on the majority's behalf the Crawley case and dropped the footnote Justice Weck alludes to, as I'm sure you know. And because we foresaw this question some 14 years ago, and sure enough, here we are, as you indicate. If one is a textualist, very much in vogue today in SCOTUS language, originalism, textualism, interpretive, etc. Can there be any doubt that 1738 invokes only intra-policy and not inter-policy, where it says conspicuously twice, under the policy and in the policy? So if you're a textualist, if you read the text and you don't care what the legislature did, isn't it clear? Would it not be as clear as can be?
Well, if the statute was entirely the rejection form, Your Honor, I might tend to agree with you, but you have to read the whole section in its entirety. And as the court did in the Crayley case, and said this section is intended to give insureds the option to reject both types of stacking. That's what the legislature intended. That's what this court has agreed, unanimously agreed. And the correction I wanted to make, Your Honor, to my brief, this is relevant to this point, because we said in the brief that both your opinion questioned whether or not this reform would be adequate if it was a multi-vehicle policy, and so did Justice Cappy's concurring opinion. But in fact, when I reread Justice Cappy's concurring opinion and preparing for this argument, I realized that Justice Cappy recognized that the legislature intended this form to waive both types of stacking, but he said they didn't do it very well. And what they ought to do is add these words, or to not just policy or policies, and that would clear everything up. But he clearly was of the opinion that the legislature intended the form to waive both types of stacking, but the form need to be improved. Now, and what I left out of my argument is that the subsection E says the insurance companies can't toy with this form. We can't change the form, okay? And so they give us one form that we're required to use. They say you have to use this form for the waiver of stacking. They don't. The form itself says, it talks about the policy, but but this is the legislature's form. It may not be the best form in the world, but it's their form. It's the form the insurance companies are required to use. The fact that the legislature didn't act in response to Judge Cappy's suggestion may mean that they didn't like his suggestion. They mean that they thought the statute was clear on its face. It didn't need to be modified. But the point is that the legislature.
Or maybe they didn't pay any attention to what he said.
Well, I didn't want to say that, Your Honor, but yeah.
That would be typical. May I ask you another question?
Yeah, absolutely, Your Honor.
Okay. No, I appreciate it. This case, and we won't beat the dead horse, but this case is distinguishable from Crawley, obviously, because here in Mom's policy, she had 3 vehicles. So she could have read 17.8 very, very carefully, astutely, as a lawyer as capable as you are, and said, aha, I am not waiving my inter-policy stacking. That's what it says. One of the rubrics that I've always tried to follow is you get what you pay for. And on one hand here, one would say, well, she waived stacking. Son's policy really doesn't matter, but he waived stacking also. And therefore, are they getting what they paid for? But Judge McHugh, who I thought did a very fine job on this case, very thoughtful job on the federal district court, he pointed out that there's nothing on this record that indicates that mom did not pay for inter-policy stacking. If she, in fact, didn't waive for it and built into the cost of the insurance that your client charged her, the premium, is some amount for inter-policy stacking, then justice is done. And I just wanted to give you a chance to respond to that.
Well, I thank you for the opportunity. I'm glad you brought it up because it also, I wanted to address something in the brief of the Donovans. There's a very unique way that insurance companies, at least for State Farm, I can't speak for all other insurance companies, how they calculate premiums for underinsured motorist coverage and non-stack coverage. And what they do here is what Mr. Haggerty says in his brief, and maybe an oversimplification, but it's pretty much on point as far as I'm concerned. There's two criteria. One, the limits of coverage that you purchase is going to affect how much you pay, and he terms the second is the geographic region. Okay, and what is meant by geographic region, Your Honor, is it's the loss experience in the geographic region where this policy was issued. So, for example, if you and I lived in the same neighborhood, I don't think we do, but if we did, and let's assume you had an immaculate driving record, the young man that you are, and let's assume that the old man that I am, that my driving record was not good at all. We would pay the same premium if we purchased the same limits of coverage anyway for uninsured and underinsured motorist coverage. We would be charged the same premium, okay? Because the premium is determined by the lost experience, all right, in the area. So State Farm is not able to come in and say, well, how much is the premium saving for inter-policy and intra-policy stacking, because it's written the coverage. It assumes all along that it waives both types of stacking. And I'd like to put it in these terms, Your Honor, that an adverse decision in this case to State Farm, okay, is okay. It's of course I don't want to see it. It'll be a temporary setback to State Farm, but the real losers in an adverse decision in this case will not be the insurance companies. It will be all the various insurers throughout the Commonwealth who pay premiums for uninsured and underinsured motorist coverage. And if you interpret the statute this form not to waive inter-policy stacking, then the loss experiences is going to go up. And then a year or 2 years down the line, everybody's going to pay for this in the form of higher premium. And I guess we all agree what Your Honor says. You should get what you pay for. And what we're saying is under the statute, when you waive stacking, this is what the legislature intended. Maybe they could have done a better job in creating a form, but they didn't need to create a form. They could have just said, had somebody sign, I reject stacking. Okay, they explain a little bit here. And the fact of the matter is that under Justice Cappy's, Chief Justice Cappy's form, and then Mr. Haggerty in his brief comes and says, look, you can make another form, but the problem with all these forms in the end have language in it and says the limits of coverage that I am purchasing shall be reduced to the limits stated in the policy. And it really doesn't address, Your Honor is right, it doesn't, none of these forms specifically address that. And I don't think that most insureds know the difference between inter-policy stacking.
Mr. Salzberg, Justice Donnie has a question, and then we're going to try to bring this to a conclusion. If we understand you.
This time. Counsel, I understand your very able argument on the intent of the statute and the language of the statute, but we're looking at the language of the waiver. And don't we have to focus on whether or not an insured is giving a knowing waiver when they are only waiving stacking under the policy.
Well, Your Honor, I understand your point, but my point is this, is that the legislature, this is what you have to decide is, what did the legislature intend this form to do?
No, we don't. And that's why I'm testing you on this. I mean,
Okay.
I understand your argument, but we are faced with a situation where an insured is presented with a waiver that says that they are waiving stacking under the policy. If that's what they are told they are waiving, then under a long line of our case law, that's what they're waiving. Whether or not the legislature intended something else or they could have written it better is really not the issue when you're actually attempting to interpret what a insured would understand from what they're signing.
Okay. Your Honor, I understand what you're saying. I respectfully disagree. Frankly, if insureds don't know anything about stacking before they look at this form, I don't think they're going to understand this form one way or another. Okay? It's really not understandable, and none of these other suggested forms are any better at it. And what it does here is that if you look at the form and you know you're waiving something, okay, they may not be, the only way to tell them how otherwise it's going to affect them is to really give them a mini policy and say, sign this. I mean, that's what the policy's for. The policy clearly tells them, you know,
Counsel, we're looking at the language of the waiver. I mean, and I'm unable to take that leap that you're taking here. It says you're waiving stacking under the policy. That was the problem that Chief Justice Cappy pointed out. That was the issue that was raised in the footnote. And back to Judge McHugh's opinion, and I agree with Justice Beer, was exceptionally well done. Did your company or any insurance company have the avenue of going to the insurance commissioner and asking for guidance on how to alleviate this problem?
Okay. Your Honor, I suppose you always can go to the insurance commissioner for guidance, but the fact of the matter is that before your decision in Crayley and after your decision in Crayley, up till very recently, all the case law, all the appellate cases that came down enforced the household exclusion in the policy. Okay? And we were prevailing in all of these cases because the household exclusion was clear and unambiguous and was enforced to preclude the coverage. Okay? And so there really wasn't a reason to go run into the legislature because they were prevailing on this issue anyway.
Except Crayley put up a big red flag. And said, there's a problem with this language, if we're faced with the case that we're now faced with 16 years later. So, I mean, and your argument is very well taken on the intent of the legislature, but the insured is not reading the legislation and interpreting it. They're reading the waiver. And I think therein lies the tension here.
I understand, Your Honor, but I still say, but where we disagree is that we're required to use this form. You've interpreted the statute to require us to give them the option to waive both types of stacking. The legislature says this is the form that named insured must be presented with to waive stacking, and we use that form. And if you can improve upon that form, if this was our form, and we said, and we promulgated the form and said, okay, this is what we came up with and we think is sufficient. And you could say, well, it's not. But it's the legislature's form. And what did the legislature intend? And frankly, as I say, I don't think you go to apply for insurance, and I think most of the people who opt to reject stacking, what they're concerned about is the reduced premium. And if they want more information about it, they can talk to the insurance agent about it and get clarification. But there's no way on one form. That's why these insurance
Mr. Saltzberg, we understand this. This is very, very circular. And we've allowed you to repeat this argument 5 times. Believe me, we understand your argument.
Your Honor, I'm answering questions.
I understand.
Chief, may I make one quick comment?
Yes, sure.
I appreciate it. Mr. Salzberg, I think you are done. I wanted to make 3 points. First of all, insurance companies are like casinos. In the long run, they never lose. Second, you sort of made the point of Gallagher. Your client and all insurance companies, and I don't mean this pejoratively, that wise counsel gave them advice, didn't care about this form because they used the household exclusion as a de facto waiver. And it wasn't until Gallagher, when we said, no, you can't do that this issue came front before. I actually had a third point, but Chief, thank you for the indulgence.
Well, go ahead if you have another point, because finish that and then we'll hear from Mr. Haggerty.
No, I'm done, Chief. I appreciate it. Mr. Salzberg, good presentation.
Thank you, Your Honor.
Mr. Haggerty.
Yes, sir. Thank you, Your Honors. May it please the court. As the court ably understands, the issue in this case is the interpretation of the Craley decision. As Justice Weck properly pointed out, in order to accept State Farm's position here, this court would in effect be overruling Craley. In the Craley decision, writing for the majority, Justice Baer had the opportunity to adopt the position that State Farm is making today, and they refused to do so. The court did not say that the form waives both inter and intra. The court looked at the form and said, on its face, it only waives intra. In this particular case, it's a one vehicle policy, so therefore it has to waive something, so it must waive inter. And then in footnote 18, as Justice Weck points out, Justice Baer correctly said, but this still does not do what is needed. The courts have said again and again, and this court has said again and again, that the waiver of stacking must be knowing and voluntary. It's an important right that is being relinquished. Keep in mind that stacking was a common law concept. All policies provided stacked coverage. In 1990, the Act 6 amendments codified stacking. And what they did was they recognized how important a right it was. And in order for it to be waived, they gave you the opportunity to waive it, but you had to do it in writing. Now, the form that was set forth did not waive and does not waive inter-policy stacking. The court recognized that. The court specifically stated something needs to be done, and nobody did anything. The companies didn't do anything. Why? Because they were continuing to make money and no one was challenging this. And then, as Justice Baer points out, when the Gallagher case came along, and Gallagher is premised upon the availability of inter-policy stacking. So this court is really the intersection of Craley and Gallagher. And essentially what this Craley says is that Mrs. Donovan had inter-policy stacking under her policy. She did not knowingly and voluntarily waive inter-policy stacking. Since she had inter-policy stacking, and inter-policy stacking is the factual predicate of the invalidation of the household exclusion, that therefore, in this case, Corey Donovan may recover under his mother's policy. The household exclusion is invalid. I think Your Honors understand that the issues. I don't want to beat them down again and again. The waiver must be knowing and voluntary. The waiver was not knowing and voluntary. There was no waiver of inter-policy stacking. The issues which were certified to this court in the first issue is, did it waive inter-policy stacking? And the answer is no. If you look at the form on its face, it does not waive inter-policy stacking. The court in Craley had the opportunity to accept that and didn't. They rejected that proposition, and Justice Weck is correct. This court to now say that would in effect be overruling the decision in Craley, and there's no reason to do that. Nothing has changed. The next question is the household exclusion then invalid and unenforceable? And under Gallagher, it is invalid and unenforceable because the factual predicate for Gallagher is the fact that Mr. Gallagher had interpolicy stacking. Linda Donovan has interpolicy stacking. The household exclusion is a hidden waiver of interpolicy stacking without all the statutory protections. Again, the waiver of stacking must be knowing and voluntary. As the court pointed out in Craley, it would have been very easy for this problem to be remedied. Justice Cappy gave them the language. Now, State Farm says, well, wait a minute, we can't go and change the form. Well, I doubt very much that a court is going to invalidate a form based upon a specific recommendation from the Chief Justice of the Supreme Court. They're then going to go ahead and say, oh, we're going to invalidate this form, keeping in mind also that Section 1731, the waiver of coverage, says the form must specifically comply. Section 1738, the waiver of stacking, says the form must comply. There's a difference there. Specific compliance and compliance is a difference. Adding the words and the policies is still compliance. Alternatively, they could have come up with another form. They say, well, how could we come up with a form that would waive interpolicy stacking? Well, they came up with a household exclusion, which surreptitiously waives interpolicy stacking. I'm sure they could come up with a form that explicitly waives interpolicy stacking. It's not hard. And they didn't do it. They chose not to do it. They chose to do nothing. And now they're faced with the consequences of that decision. And that decision is that the form they used did not waive it. The industry was on notice. The industry has done nothing. And the industry must live with the consequences of their decision to do nothing, to continue to enforce the household exclusion, because the household exclusion did what the waiver would do. A correct waiver, the household exclusion, as Justice Baer pointed out, the household exclusion eliminated interpolicy stacking. So they said, well, as Mr. Salzberg pointed out, we were winning all these cases. Yeah, they're winning all these cases based upon a household exclusion. You didn't have to look at the waiver form. You didn't have to focus on what they did in Craley because they were winning the cases. Then Gallagher comes onto the scene, and all of a sudden, now they're saying, well, wait a minute, you're changing the rules of the game. The rules of the game were not changed. They knew what they were, and they decided to play it, and they should face the consequences of their decision. The last question is this coordination of benefits section. Is that, should recovery be reduced from 100 to 50? Keep in mind that Mrs. Donovan paid for an unstacked limit of coverage. She had 3 cars. She paid for $100,000. State Farm says, okay, if we owe it, we only owe 50. What they want to do is, and as I pointed out on our brief, if you take the same situation, you take someone who has 3 cars that lives, as Mr. Salzberg said, in the same neighborhood as Mrs. Donovan, buys the same amount of coverage, but there are no other vehicles in the household. They pay a certain amount, in this case, $78.32. If you take the exact same person, but there's a son in the household who owns a motorcycle, okay, now what do they pay? The exact same amount, $78.32. But because there's another vehicle in the household, State Farm says, well, when there's a loss now, we get a credit for what the son's was paying under his policy. We corrected a premium for 100, but we're only going to pay you 50.
Can I jump in there, Mr. Haggerty?
Yes.
I'm not sure if the district judge didn't make an error here. If you look at the deck page, she bought W3 coverage,
Yes.
not W coverage. And why, as a matter of contract, isn't she bound by that?
Well, because you're right, she did purchase W3 coverage, but the W3 coverage is the unstacked coverage. In order to effectuate that election, you have to have a waiver. If you don't,
But she did waive intra-policy. She waived intra-policy stacking.
Yes, she did.
Right?
But she didn't waive inter. And the limitation is in the W3 section of the policy. It's not in the W section. It's that State Farm rates their policy a little differently than some companies. Some companies will say the limits of coverage and they address stacked and unstacked. Other insurance address stacked and unstacked. State Farm has 2 separate sections, a stacked and an unstacked. So yes, she did buy W3 unstacked, but that purchase is only valid under 1738 if you have the form. So let's say that she had signed no form here. Her deck page still would say W3, but she would have stacked coverage across the board because there was no waiver. 1738.
Even though in this case she did waive intra-policy.
She did waive intra-policy. She did because the form only waives intra-policy, so she didn't waive inter. So therefore, if she didn't waive inter, the W3 limitation on inter is in the unstacked portion of the policy. She did not have that coverage. So therefore, that would not apply. That would not apply to her. I mean, you know, these stacking cases, sometimes it's like conjugating verbs in Latin. They can get rather difficult, and each company writes their policies a little bit differently, and so they must be looked at. But we want to keep in mind, this is a contractual claim, and too often, and I think as Justice Bayer did in the Gallagher case, he correctly said, let's look at the policy, and let's look at the language of the policy and compare it to the statute. And let's see what we have. Too often, primarily trial courts neglect to start at the beginning, which is a contract claim. Let's look at the contract and see what the contract provides. And here, the contract had waiver of intra, no waiver of inter. So she would have had an amalgamation of W and W3 for intra and inter. Under 1738, that's the only way that it really can be it can be interpreted. So the answer to the last question, we respectfully request that the court say that also is no, it's not applicable. But then we also say, based upon the example which I just discussed in terms of premiums, it's not enforceable. And so I respectfully request that the court affirm the decision of Judge McHugh in the district court.
Thank you. Thanks to both counsel. And with that, we'll conclude our argument session today. And we'll reconvene shortly.
Thank you very much, Your Honors. Thank you for your time.